and Tracey, I believe we are live. I think we should go ahead and get started here. And Mike, I'll turn it right over to you.
Thank you, Jason. Welcome, everyone, and thank you for joining us for today's webinar. For those of you who are not familiar with our firm and the faces on the screen, we are a law firm of approximately 30 attorneys who focus on labor and employment and education law. Today, we have a wide variety of participants on this webinar from all sectors of our client base, and we welcome you all. My name is Mike Warner. I'm a partner in the firm, and I'm co-chair of the firm's Labor and Employment Practice Group. I am joined by my fellow co-chair of the Labor and Employment Practice Group, Tracey Truesdale, and also our colleague, Jason Patterson. Before we get started, there are just a few housekeeping matters to address. If you have questions, and we do encourage questions, and we'll get to as many as we can, please use the Q&A box at the bottom of your screen, not the chat function. We will be monitoring the Q&A box, and we'll do our best to get to all your questions. Everyone logged in today's program will also receive an email at the end that includes a link to the recording of the webinar and a link to a feedback survey. Today, for all of you lawyers in the audience, we are offering CLE credit. For those of you who would like to get credit for today's presentation, you must complete and return the feedback survey to be eligible for a certificate showing that you participated today. And so let's get started. So today's focus is going to be on what's been going on in the first 30 days of the Biden administration that impacts employers. So first off, for today's seminar, we're really looking at the big picture because there's still a lot that we don't know as far as the details. But what we do know are trends and priorities of the next administration. And we're going to do our best to read the tea leaves and tell you how we think those trends are going to evolve and how they are going to impact you and your organization in your status as employers. First off, as you probably heard in the media, the top priority right now of the Biden administration and Congress is passage of a pandemic relief and recovery plan. This is the $1.9 billion rescue plan. The official or unofficial name for it given to by the administration is the American Rescue Plan. That obviously is priority number one of the administration, public relief in dealing with the pandemic and recovery of the pandemic. Next issue that we believe is going to be a top priority that will impact employers is our issues of equity and social justice. Those topics justifiably have taken front and center since some of the events of this summer in the wake of George Floyd and Breonna Taylor and other events. Finally, of significant importance and impact to employers is the strong support of organized labor and employee rights that we can expect coming out of the Biden administration. And as you'll hear from Jason in particular during his section, the sea change that we anticipate can't be stressed enough. Under a Democratic administration, you always expect the Department of Labor and the NLRB to move in a more progressive direction, more pro-labor direction. But this is, from what we see, this is going to be the most pro-labor administration, perhaps since Roosevelt. much more so from what we see, given who Biden is placing in key positions than under Obama. Obama had a lot of people around him who came from more of a corporate boardroom, Wall Street background as opposed to a union background. And so we see even a stronger support for labor than what we saw under the 8 years of Obama. So the American Rescue Plan. How do we see the American Rescue Plan impacting organizations in their capacity as employers? First of all, as you may have heard, part of the plan currently floated by the administration includes a staged minimum wage increase that would result in ultimately an increase of the minimum wage nationwide to $15 an hour. The tea leaves that we currently see suggest that for various reasons, some political, some procedural and logistical, that's becoming increasingly unlikely that it will be part of the current package. Some of the more moderate Democrats, such as Joe Manchin, are not necessarily on board with the increase, as well as because it's increasingly likely that the legislation is going to have to be passed through budget reconciliation. There is a concern that the minimum wage increase, which doesn't necessarily have a direct impact on the federal budget or the spending of the federal government, might not be doable through the reconciliation process. Finally, there are some concerns raised about the economic impact of the minimum wage increase to $15 an hour. The CBO came out with a report last week saying that it may have a negative impact on the economy and economic extension. From a legal perspective, one of the most significant impacts that Tracey will talk about more in a few minutes is that the legislation does propose a reinstitution of the FCRA COVID leave provisions that expired on December 31st of last year, as well as an expansion of FCRA provisions to a broader group of employees than was the case under the original law. Finally, for those of you who work for state and local government entities, part of the package is a significant amount of direct funding for state and local government support. From a legal standpoint, there's no specific employment law that's impacted, but it obviously will impact your organizations from a standpoint of staffing and funding, and hopefully avoiding some of the tough decisions that have been that your organizations had to make during the COVID crisis. Okay, we can move on. So having talked a little bit about what we see on the legislative front, what I'd like to turn to and spend the bulk of the presentation on is what is happening in administrative agencies. Because those of you in this area know that even without legislation and new legislation being passed, what the administrative agencies that affect employment and labor can have a significant impact on the legal landscape and environment. So what we can expect and what we've already seen so far is obviously there's new folks at the top, new agency leadership, and their backgrounds suggest a sea change in how the Department of Labor will approach policy issues. We've already seen a walking back of Trump wage hour policies. and most significantly on issues of independent contractor and employee misclassification. So first of all, Biden has proposed for nomination, and I believe right now it may have come out, he may have passed the committee level, but it has not yet been confirmed by the Senate. Secretary of Labor, Marty Walsh. Walsh has a very strong union background. He is a former construction union president. He's the former mayor of Boston, where he had a reputation as being very labor friendly, and also very aggressive on compliance as far as COVID-19 protections for employees. As I mentioned, very pro-union, but he also does have a reputation as someone who tries to build a consensus. In the deputy secretary slot, we have Julie Sue. She is out of California, currently secretary of the California Labor and Workforce Development Agency. She also is strongly supported by unions and employee advocates for her pro-enforcement philosophy, and also making sure that employees understand their rights. And for those of you on the phone who work for, or on the screen today, who work for companies or entities with operations in California, you know that the dynamic of regulation and employment and labor-related enforcement in California, in terms of the highly regulated environment that employers in California have to work under. And so you can anticipate she is going to bring much of that philosophy to her role in the federal government. So what we see already and on the horizon in terms of regulatory changes, all pending Trump era regulations at the Department of Labor have already been frozen by executive order. There were several that were set to go into effect that are frozen, some of which may go into effect in modified form, others which are probably dead on arrival. Most significantly, the DOL had proposed and approved a new rule simplifying the test for determining whether an individual is an employee subject to DOL law regulation and laws within the DOL's jurisdiction, such as the Fair Labor Standards Act, or whether they are independent contractors and not subject to requirements such as minimum wage, overtime rules and laws. The rule was set to go into effect on March 8th. It simplified the test to really focus on the economic reality of the relationship between the contractor and or the individual in the company they worked for. That rule is effectively dead on arrival. So for now, and for the indefinite future, we expect the traditional 12-factor test that's somewhat amorphous will continue to apply at the federal level. Given the appointments to the administration, we could also expect a push towards, again, more of a California style definition of employee, which, if those of you who've been following California, they recently passed legislation that greatly restricts the ability to classify an individual as independent contractor. It's had gotten most of its attention with respect to its impact on the gig economy, Uber, Lyft, DoorDash, and entities like that who successfully won a referendum that overturned the application of the California law to those gig economy entities. Other significant termination of Trump-era initiatives was the termination of the voluntary wage hour compliance program that provided a safe harbor for employers who sought guidance and self-disclosure of wage and hour issues. Again, this is a signal of more changes to come and a shift from assisting employers in complying to aggressive enforcement of the wage. So now I turn it over to Tracey to talk about, probably in light of the current COVID situation, one of the highest priorities within the Department of Labor, if not the federal government writ large.
Okay. Yeah, OSHA tends to be, or historically has been industry specific. We're usually talking about construction and manufacturing sort of being the targets of the Occupational Safety and Health Administration. But under the pandemic, with COVID-19 affecting virtually every workforce, every employer should have workplace safety on their mind right now, because even with our public sector clients, you are governed by the Illinois Occupational Safety and Health Act, which will look to the federal government for how it enforces its standards and for the standards themselves. So, as I said, even for law firms and other service providers that ordinarily are not governed by OSHA or concerned about compliance, every workforce needs to start thinking about how to, if you haven't already, how to manage the pandemic. So we'll start off talking about who's now in charge over at OSHA, what new rules and standards are coming, how do we expect enforcement to change, and how can you all prepare when it does. The president didn't waste any time getting ahead in place at OSHA. During the Trump administration, there was no assistant secretary for OSHA. It was an acting role. And she was fairly passive in terms of new standards and enforcement. It was Loretta Swett. Jim Frederick comes out of the steelworkers. He has 25 years doing EHS, so he's going to have a heavy manufacturing background, lockout, tagout, respiratory protection, those kinds of things will be things that he is quite familiar with, having come out of the steelworkers. So he is already in place. He's not subject to confirmation by the Senate. We also have a brand new position created pretty much specifically for COVID-19 and the pandemic, Deputy Assistant Secretary for Pandemic and Emergency Response. This gentleman, Joseph Hughes, has 40 years of experience doing EHS and developing occupational health education programs for high-risk occupations. He has experience in large-scale crises like 9/11, like Katrina, Ebola, and even COVID-19. So, we expect is going to get things moving with respect to regulation of employers and how employers are dealing with the crisis, because that's what he's charged with doing. It's a COVID-specific position. So what do we foresee on OSHA's regulatory agenda? Again, the president wasted no time. On January 21st, 24 hours into his tenure, he issued an executive order giving OSHA a fairly robust to-do list of things that he wants considered and or implemented. First item was he directed OSHA to issue revised COVID-19 guidance within 2 weeks, so by February 4th. I'll talk about that guidance, but it did issue. It issued on January 29th. He's asked the agency to consider an emergency temporary standard addressing COVID-19 by March 15th. And I expect that we will see that kind of a standard. Again, you have Joseph Hughes in place, and I expect he and his staff are working on that. He's directed the agency to focus their efforts on violations that have the largest number of employees at risk, and also violations alleging retaliation, what we would call an 11C kind of case. We have seen, even under the Trump administration during the pandemic, OSHA has focused on what I would call low-hanging fruit, those employers where exposures are significant, because when we look at those businesses that were cited over the course of the pandemic, they are primarily in healthcare and in skilled nursing care. And we know, based on how we're screening and vaccinating employees and prioritizing, that healthcare is obviously an area that's extremely high risk for infection with COVID-19. So OSHA has identified that and has gone after those employers even under the last 9 months or so of the Trump administration. The president has asked OSHA to create a public outreach campaign to educate employees on their OSHA rights. Right now that's pretty much just a poster on the wall, but I think we're going to see more aggressive methods of educating employees, whether it'll be by videos. OSHA has a lot of that kind of content available, but it's usually employer facing and really not communicated down to the shop floor. So I expect we will see greater outreach to the worker out on the production floor or on the construction site, that kind of thing. And the president has asked OSHA to coordinate with their counterparts at the state and local workplace safety level to ensure that employees who are not otherwise covered by the federal OSHA statute are protected during the pandemic. So OSHA's revised COVID guidance. I've included a hyperlink, which hopefully will work in your written materials that you received. It was released on January 29th. What OSHA did make clear is that this is not a standard, it's not a regulation, and it creates no legal obligations. So it is strictly advisory in nature. This is sort of a best practices kind of guidance. It's not something that you can be cited for not complying with, but it certainly makes fairly strong recommendations about what employers should be doing and that we may see codified in a standard come March 15th. And really, the revised guidance asks employers to focus on developing an effective COVID-19 prevention program. And I don't have them all here, but there are 16 elements that OSHA has identified. And to some extent, what OSHA did in, when the president said, I want you to, to revise your guidance, they kind of looked at, their peers over at EEOC and said, well, what are some of the things that EEOC is saying are either okay to do or that we should be doing? And they've added those into sort of a global COVID-19 prevention program. So, the couple of things I want to highlight here, and we could do an entire, webinar just on the elements of a COVID-19 prevention program. But the second and third bullets there on hazard assessment and hierarchy of controls. I think a lot of employers who are not accustomed to dealing with workplace safety as part of, the day-to-day operation, we talk about face coverings and we talk about masks, things that may or may not qualify as PPE, but let's use that term. PPE is always supposed to be a last resort in the workplace. That's OSHA's mantra. We give an employee, a gown, we give them a mask, we give them a respirator, we give them goggles. Those are things that we give an employee because we cannot completely eliminate a hazard in a different way. What OSHA tells us it wants us to do is to apply what's called a hierarchy of controls. And that's looking at, can we do things by engineering, or can we do things administratively? So engineering controls and administrative controls to address a workplace hazard. Engineering controls in the world of COVID-19 are things like installing the plexiglass barrier that we see in retail stores, or that I know some employers have installed on cubicles and things like that. Those are things that we can implement to maintain the spread of the virus, to prohibit the spread of the virus physically. Administrative controls are things like reducing your scheduling of folks in the office or in the workplace to half staff, having the flow of employees up and down staircases, going up on the right side and coming down on the left, to keep people from maintaining maintain the 6 feet distance. Those are the things that OSHA wants employers doing first, before we rely on things like masks, gowns, face shields, those kinds of things. So bear that in mind when you are dealing with COVID-19 in the workplace. OSHA, the EEOC has encouraged employers to do things like use telework and other supportive policies, including paid leave policies, to keep those employees who are higher risk from having to come into the workplace if they don't have to minimize their exposure and possible infection. And those are things that we've heard about from the EEOC all along, that they would like to see employers in the context of assessing employee risk coming back into the workplace. Is it possible to keep people productive and working at home by remote? And so OSHA has latched onto that in this COVID-19 prevention program guidance. And then the other item I'd like to draw your attention to is the employee vaccines piece that I bulleted there. What OSHA has recommended is that employers offer vaccines to their employees at no cost, and also educate and train employees on the importance and safety of the vaccine. And that's a fairly strong position for OSHA to take, even though it's not a standard or a regulation, because the vaccine, to tell an employer that they should be affirmatively training and educating employees about safety of the vaccine itself, when the vaccine is coming from a third party, is sort of an aggressive position, because there are other concerns, and I'll talk about those in a moment. So that is something that OSHA is recommending, and that we may ultimately see in a temporary standard. So when we look at the elements that OSHA is recommending in terms of COVID-19 prevention in the workplace, some of them have other legal implications. OSHA recommends that employees be screened, which could include testing for COVID-19, the whole vaccine issue, if you require employees to be vaccinated. If you have a union in your workplace, you are going to have collective bargaining obligations over implementing any requirement like that. Testing is almost always a mandatory subject of bargaining. You may have some kind of foothold in your labor agreement, but it's pretty unlikely. So testing is going to be something that you're going to have to bargain over, as would be a requirement that employees be vaccinated potentially. ADA issues are going to come to the fore if we're talking about evaluating whether an employee should be allowed to continue working from home, or whether their presence is required in the workplace. And then obviously, if you're going to give people time off, or employees time off to because they can't come into the workplace, that can implicate, FCRA, as Mike mentioned, as well as the FMLA, and here in Chicago and Cook County, the Chicago and Cook County paid sick leave ordinances potentially. So if we get a COVID-19 emergency, a temporary standard, what does that mean? What's an emergency standard? Well, it means that OSHA adopts the standard first, and it worries about comments from the public and from interested parties like manufacturers and other stakeholders. It worries about those comments later. So the standard goes into place first. Not all that different from what happened last spring, when the Department of Labor issued rules pertaining to the Families First Coronavirus Protection, or Coronavirus Response Act. So we'll see that standard come out, and you'll be expected to comply before any comment period is held. We expect that OSHA will draw on existing state emergency temporary standards and plans. California has that kind of standard. Michigan has a quasi standard, and Virginia also has an emergency temporary standard. So we expect that OSHA will look to those programs and standards to develop its own standard. And if a standard is adopted by the agency, that will be something that you will be expected to comply with. It's now no longer advisory or suggested. And in terms of state OSHA plans, which, as I said, in Illinois, that's going to cover our public sector clients, including school districts. State OSHA plans have to meet those federal standards and be at least as protective, if not more so. They can always choose to be more so, but must provide for at least as much protection as the federal standard. Currently, the OSHA Act only applies to private sector employees and to some extent federal sector employees. But the President's COVID-19 relief plan includes an ask to extend OSHA's jurisdiction to public sector employers and to give the agency the authority to address violations. And, you know, my reading of the tea leaves there is that's going to require amendment of the OSHA Act. Oops. Trying to close something else out there. Okay. So whether that will be achieved in the time that we need it to be, it was yet to be seen, because with the vaccines rolling out, whether the President's really going to get expansion to public sector employers is a fairly big task. How will enforcement change? Well, again, we could spend a lot of time covering this topic as well, but you can expect that the President is going to increase staffing. During the Trump administration, OSHA hit an all-time low of 752 occupational safety and health compliance officers, what we call COSHOs, and President Biden has called for a doubling of that number. So more compliance officers means more inspections, means more citations, means more penalties. It's very simple. And we see that sort of ebb and flow that Mike mentioned in his presentation. In a Democratic administration, we see a much more aggressive OSHA. During a Republican administration, we see a much more pro-business, pro-employer OSHA. The one thing that Jason and I, practicing in the space, are lucky to have is we have very good relationships with the leadership in the Chicago area OSHA offices. And so those individuals, while they may move around within the Chicago area and move from office to office, or are replaced by some of their staff as they retire, they tend to be career OSHA professionals because they are trained on occupational safety and health. You can't just put anyone in one of those jobs. And so even though we will see a change in sort of the approach to enforcement, we will probably be dealing with the same people that we've dealt with for years. So, and we see that sort of change in their aggressiveness with the change in administration. It's kind of an interesting thing. We also expect that OSHA will return to the Obama era scrutiny of post-accident drug testing and safety incentive programs. This too is a topic I could spend an hour on, but basically under President Obama, OSHA was asked employers to dial back on drug testing employees who are involved in accidents. If you had a policy that said we test anyone involved in or present for an accident, that was deemed to have a chilling effect on employees' statutory rights. And the Obama era OSHA also took aim at safety incentive programs that rewarded employees for remaining, quote, accident-free. Anyone who's gone by a major construction site has seen, the little placard on the outside of the fence that says, we are 119 days accident-free. OSHA sees that as a problem because it encourages employees not to report their injuries. So we expect that there will be a reversion back to that. And we also expect that the agency will act on long promised standards, including workplace violence, and finally adopting an infectious disease standard. OSHA has been working on an infectious disease standard since the H1N1 epidemic in 2010. So we're 11 years out and we still don't have one. Presuming that OSHA adopts one, it would likely include and cover COVID-19. So what can you do before all of this happens? Well, you can create a COVID-19 prevention and control plan before it becomes a legal requirement. And Jason and I have worked with a number of you to do, if not a comprehensive plan, certainly pieces of a plan. And we're happy to do that for anyone else who may have questions about that. But I think our clients have been very proactive that way. And as I said, they've gotten a good start if we haven't hit all of the elements in OSHA's prevention program guidance. So create a written plan. You want to educate and train your employees on the plan, and you want to follow it. A plan that's written and that's saved to a hard drive and nobody sees it, OSHA is never convinced by that. Failure to train, as I say, there is low-hanging fruit. We get lots and lots of citations for failure to train because it's very easy for OSHA to say, great, you had this document, we're not even going to question whether it meets the standard, but because employees didn't know about it or didn't know what it required, you didn't train. So bear that in mind, that if you have a COVID-19 prevention plan, you got to get your employees on board. Hand in hand with that is documenting your compliance, whether that's keeping attendance sheets, showing that you have disciplined employees for violating your prevention plan. Those are all things that OSHA looks for. And you should have that at OSHA response plan before a compliance officer is at the door. That's the ideal situation, certainly. And now I'll switch to talking about the Families First Coronavirus Response Act. That's the leave that Mike mentioned. FCRA allows employees to take time off, either if they're quarantining for or have been diagnosed with COVID-19 or are caring for someone who has been diagnosed with COVID-19 or is waiting for a diagnosis. And also if the employee's childcare or child's school is closed due to COVID-19. And as Mike mentioned, it provides for up to 12 weeks of leave. That leave expired, that statute expired on December 31st, but Congress did enact a provision that allowed employers to continue, who voluntarily opt to provide the leave, they can continue to take the tax credit for the wages that are paid under FCRA through March 31st. FCRA, as was originally written, only applied to public sector employers and private sector employers with 500 or fewer employees. That was a sticking point that I know a lot of lawyers and a lot of clients, when we first saw the statute, we kind of read it and said, that doesn't make any sense. I must have read that incorrectly, because it really kind of made no sense that our large employers across the country were not required to provide this paid leave to their employees. So that's what the statute says, and the statute also allowed employers of healthcare workers and first responders to exclude those employees from eligibility because they were needed during the pandemic. So what the president is proposing is two things. As part of the American Rescue Plan, he wants to ask Congress to reinstate the paid leave provisions through the end of September. So we'll have another 9 months. And then he wants to expand coverage. It would be expanded to include businesses with fewer than 50 employees, and finally rope in those employers of 500 or more employees, along with the federal government. They would all be covered by FCRA if it's expanded. The exclusion or the ability to exclude healthcare workers and first responders from FCRA, that will be eliminated. So those folks will be now eligible for FCRA leave. The amount and duration of FCRA leave is expected to increase so that employees may take up to 14 weeks. Actually, there's a kind of a funny scenario under which that can happen, but the amount of benefits will increase to up to $1,400 a week, which is a significant change because right now the cap is at 500. the proposed extension would still allow employers with 500 employees, with fewer than 500 employees, to take the tax credit, and will finally allow state and local government employers to take the tax credit as well. And I know this has been a problem for a lot of our education clients, because you've provided this leave and you haven't been able to take the tax credit. We still can't tell from the American Rescue Plan whether that will include school districts, but hopefully it will extend to that as well. So that tax credit basically makes the payment of the paid leave a wash for the employer. That, you know, as long as you only apply or provide leave up to the dollar cap that FCRA requires, you get an immediate tax credit. So the idea is that really the federal government is paying for that leave time. So hopefully that will be extended, as I said, to our school clients. And employers with 500 or more employees, now that they will finally be covered, if this materializes, they will not be eligible for the tax credit. So you're seeing a marked change in position between the Trump administration and a Republican Senate, certainly to this Democratic Congress and administration, requiring business to shoulder more of the cost here. And I'm going to turn it back to Mike to talk about the EEOC.
Thank you, Tracy. As I mentioned at the outset, what we see is kind of the second major bucket that the Biden initiatives are going to fall under in priorities in the areas of equity and social justice. And from the employment perspective, the two agencies that most responsible for those sort of issues of discrimination and equity, are the EEOC and OFCCP. OFCCP, as many of you know, particularly if you work for a federal contractor, has jurisdiction over employers that are federal contractors to the federal government, provide products or services to the federal government. That is OFCCP. Their orders and regulations are accomplished through executive order and presidential action. It does not require legislation because the government's exercising its power to contract and can enforce terms through the contracts they enter into with their providers. So that's where we expect to see immediate, and already have seen immediate action by the Biden administration. Does not depend on Congress. Day one, Biden rescinded Trump's executive order on racial equity. As some of you know, Trump signed an executive order that, first of all, the first thing Biden did was entered a series of orders promoting equity initiatives and social justice in all aspects of society, including employment. Those are wide-ranging and impact really every aspect of the federal government. Next slide. Within the EEOC, which, as you all know, in the employment realm, enforces and investigates the nation's federal discrimination laws. We've already seen some changes as far as shuffling the seats within the commission. Biden has the commission is members of the commission have fixed terms. But what Biden has done already is the current chair of the commission, Janet Dillon, appointed by Trump and Republican, has been replaced in the chair position with Charlotte Burrows, who is a current commissioner. She was confirmed as on one of the Democratic seats on the commission in 2019, and her term lasts through 2023. She is a longtime Department of Justice attorney who has focused her career on employment and civil rights. She was a longtime staff member of the late Senator Edward Kennedy. Among the initiatives she spearheaded was in the employment realm was the passage of the Ledbetter Fair Pay Act, which, as many of you may know, loosened and made more employee-friendly the statute of limitations applicable to claims of pay discrimination, so that essentially every paycheck that has been potentially affected by a past discriminatory decision is in and of itself actionable and can count toward, can be form the basis of a discrimination lawsuit. Also was very involved in the amendments to the ADA that broaden the definition of disability and who is protected by the ADA. So currently the commission is still in Republican control, 3 Republicans and 2 Democrats, and this is expected to last until July 2022. And the EEOC is and the NLRB, as Jason will explain in a minute, because of the appointment process and the makeup of the commission and labor board, you generally, in terms of official regulations, official commission or board action, there is a lag in typically when administrations change over. There's several years before the administration can in office can gain control of the chair at the top. That being said, you can go to the next slide. From those of us on the ground who work with the EEOC, we can expect to see changes immediately again, because we know the administrator, we know the priorities are going to change. The people we work with and interact with are career officers. They know what's coming. They can expect possibly additional funding coming forward. And there are going to be changes occurring within the rank and file that will be prepared to push forward a different agenda once the new commission is in place. So what we can expect to see over the next few years is going back to an increased focus on data collection. We can anticipate reinstitution of Obama-era EEO1 initiatives focusing on collecting more robust data, particularly on issues of pay equity and gender and race pay equity. We can expect a renewed focus on systemic litigation. So those of you who are faced with EEOC charges that may raise systemic issues, you need to be aware that those create risk factors. Even if the charge is filed today, it takes time to investigate. When an investigation is done, by that time and a decision is made whether to proceed with litigation, a new commission and new leadership may be a place that is more open to pursuing those types of large systemic claims. One of the areas in which the Trump administration pushed in a more aggressive enforcement agenda was on the issue of religious discrimination, in particular claims that were focused on employers who and then employees who expressed traditionally Christian values in the workplace. Those claims are going to be de-emphasized. Again, a lot of all these enforcement initiatives depends on how much money the agencies have to spend. As Tracey notes, we can expect a lot more funding for Osha, obviously given the priority of COVID relief. It remains to be seen, how much oxygen, how much funding COVID and the pandemic is going to take up, and whether there's going to be resources to divert to other democratic priorities such as EEO enforcement. Okay.
Go ahead.
All right. So back. So with respect to the OFCCP, there is a new OFCCP director already in place, Jenny Yang. Again, very pro-enforcement, pro-data collection background. OFCCP, we can expect, because they're not beholden to congressional approval or legislation, this is where we can expect the most immediate and aggressive changes to enforcement and change from the Trump administration. What we've already seen, and I began to mention earlier, is Trump had initiated or signed an executive order that restricted what, according to the Trump administration, was divisive anti-racism and diversity training for federal contractors, and also set up a complaint hotline for employees who believed they were required to participate in training that they viewed to be divisive and inappropriate to complain. That was immediately rescinded on day one and is no longer required for, no longer applicable to federal contractors. We can expect more aggressive actions and potential new executive orders. As I mentioned previously, it's looking increasingly likely that across the board $15 minimum wage, federal minimum wage for all employers is not likely to happen in the current pandemic relief legislation. But in lieu of that, what we can expect is a $15 minimum wage implemented for all federal contractors through executive order. And now with that, I will turn it over to Jason to tell us a little bit about what's happening in the world of labor relations and the National Labor Relations Board.
Thanks, Mike. And to jump right in, there's a lot happening, and depending on what side you fall on, it's either positive or negative in your view, but nonetheless, there's a lot going on. And I don't know how what the makeup is of our audience as far as how many people practice or are involved with labor relations, but it's very unique because you're dealing with the same parties all the time. You have, decades of bargaining experience with the same party. And so that kind of creates the situation where the law changes so much that, you're running this marathon and you look behind you and people are going a different direction because the rules changed. And so that's kind of how, you want to kind of view this topic. In 2021, perhaps we'll see some of the biggest changes in this so to speak race that we've seen since it began. So a couple of things on the horizon at the NLRB: agency leadership changes, board composition, and just to make a distinction there, when we say agency leadership changes, we're talking about the general counsel's office that directs regional offices that actually enforce the Labor Act and administer administrative proceedings regarding representation petitions. And then the board is the actual 5-member body that sits and rules on lower decisions, and their decisions become effectively the labor law. So there's also some legislation / rulemaking, and I put in parentheses the big one. I'll tell you about that later. And lastly, anytime there's an administration change, you can anticipate that some of the key board decisions, depending on the board makeup, will also change. So the first change that happened right away was the installment of Chicago's own Regional 13 Regional Director Peter Orr was served as acting general counsel until yesterday. So while his time as acting general counsel was brief, he took swift action on his predecessor's initiatives. I'll just kind of briefly highlight a couple of things that Mr. Orr did. Number one, he withdrew a pending brief that argued that the current contract bar limits employee free choice. And what that means is during the life of an initial collective bargaining agreement, or for a period at least of 3 years, that there is a presumption that the union still has majority support of those employees, and it cannot be challenged by employees wishing to decertify the union or a rival union wanting to come in to take over. So during the initial portion of that contract, that stands. The prior general counsel took the belief that limits employee free choice. So that was a brief that Mr. Orr was able to remove right away. Secondly, and these are just three. There's actually a list of things, but these are the three I just want to point out. He also rescinded an agency memo addressing how the board would approach handbook cases. And if you practice in this area, and even if you don't, you may know about the board's treatment of handbook rules. Basically, we'll go through a rule book and say, okay, would a reading of this handbook or this work rule cause someone to be restrained in their exercise of their Section 7 rights? Would it somehow coerce their or restrict their union activity? And so there has been some back and forth, some ping pong, so to speak, amongst the board and how these policies are analyzed. And under the Trump board, there was a decision in a case called Boeing that sort of took a different approach, that not only will they look at whether this rule would reasonably construe or an employee would reasonably construe this rule to restrict their rights, but it sort of took into account the employer's position and the harm to the employer if this rule was found to be unlawful. Mr. Orr withdrew that memo saying that, hey, at this point, we have a lot of board cases that have interpreted the Boeing case. We don't need an extra agency memo. And that kind of teased up the board to make a change if they see so, depending on, and I'll get into what the board makeup is now. Lastly, there was a complaint previously filed. I think most of you know about what we call Scabby the rat, which is a big inflatable, just, kind of scary looking rat that you'll sometimes see outside of workplaces. You may see people walking around with picket signs. And just to give you kind of a background on why this is significant, with roughly 1.4 million caveats, it's unlawful for a union to put what we call secondary pressure. So if Union A has a dispute with Contractor B on a job site, there's only so much they can do to pressure maybe the owner of that job site if they don't actually have a dispute with that entity. And so the law does allow things like hand billing. So even if I have a dispute against Contractor A on the job site, and I want to hand out leaflets or handbills in front of the property owner's portion of that site, I can do that so long as I don't cross a certain line where it becomes what's called a secondary boycott or secondary picket. Well, for a while, the law allowed this rat to not cross the line, but under the previous administration, they were seeking to essentially get rid of the Scabby the rat and said, hey, this is more than hand billing. This is coercive. This is unlawful secondary picketing. So Mr. Orr withdrew a complaint that had previously been issued against a union on that basis. So we think Scabby the rat will be okay for a little bit, but this is going to be one of those things that we also watch closely. And while it's kind of fun to because this is a big ridiculous looking rat, it still signals, you know, there's some bigger implications about, you know, what constitute coercive secondary action that I think the board is going to have to discuss on this coming term.
And Jason, it's worth noting that this area and topic in particular has potential application to school districts and our public sector clients, even though their employees are not subject to NLRB jurisdiction. This has implications for any of our clients who may, you know, have private contractors who are doing construction work on site that may have where the construction firm may have a labor dispute with involving its workers.
Absolutely. And even to speak to that, over the summer, we saw a lot of increase in Scabby the rat was everywhere, including on some school district property. So we've dealt with that issue recently and advised clients through that, particularly over the summer when I haven't seen them out too much lately, for obviously reasons, blizzards out. So moving on, just yesterday, a longtime NLRB employee, Jennifer Abruzzo, was appointed to general counsel. And so she, at the time, or currently is in the special counsel for strategic initiatives for the communication workers. But prior to that, she had 23 years of experience as a field attorney, deputy regional attorney. I think she may begin her career in Florida, out of the Miami regional office. But she also spent time in the deputy general counsel's office, division of operations, which is a division that handles a lot of the day-to-day functioning of the regional offices. So we would expect her to continue a more aggressive push that was started by Mr. Orr as well. So to give you an idea of the changes to the board's composition right now, we can expect change to we can eventually expect the Democratic board, but it may take a while. So currently there's 3 Republicans with Chairman Farron being the sole Democrat on the board, but there is a vacant seat that will expire this year, and that was former boardman Mark Pierce's spot. That expires in 2020. Well, that doesn't expire to 23. But at that time, when there is an appointment, that would raise the majority for the Republicans to 3-2 until Emanuel's seat expires in August. And so August would be the earliest time where we could expect to see the board shift to a 3-2 majority, which is why it's not surprising that you're seeing a lot of, rescinding of GC memos and proposed legislation, because the board is not going to immediately align with the president's agenda. So it's not, there's still some competing interest, and I think there will be for most of this year. But depending on how long it takes to actually appoint a new board member in August, if there's any type of legal battles or anything like that, it may take longer. So that's one thing that remains to be seen. So when I said the big one, this is in reference to Protecting the Right to Organize Act of 2019, which is, you probably heard as the PRO Act. And it would represent the most significant labor reform since the Taft-Hartley amendments, which actually led to the National Labor Relations Act. And I know many people may recall the Employee Free Choice Act, which essentially just eliminated the need for union elections in some situations and allowed for a card check. This bill goes much, much further. Thanks. So I just want to briefly touch on some of what is in this bill. Again, we don't know, with it being this radical, we don't know what's going to happen. We don't know if it's going to get passed in this form, but that remains to be seen. But one thing that happened that's in the bill would be codification of some of the Obama era board decisions. Again, the board decisions ping pong all of the time. And so this is a way for some of those some of that precedent from that era to just be in the law. So a couple of quick ones. One, Browning Ferris Industries, which is a discussion of the joint employer test. The board recently, well, not recently, last year, implemented its own joint employer rule, and the case law has gone back and forth on that. But the thing that tends to go back and forth is just the extent of control needed for an employer to be held out to be a joint employer. And you see this most often in the franchisee-franchisor relationship. And the key element, without getting into all the details, is whether there's going to be an existence of, can you be a joint employer just because you either reserve the right to control the workforce, or you have some sort of passive power to be over a workforce. The franchisor, a big restaurant chain, has the right to direct, but do they actually? So, under the traditional test or prior, it was more so you needed that direct relationship. You really needed to be able to control that workforce. Browning and Ferris kind of changed that and said some type of indirect is enough. Even if you existence of reserved joint control or indirect control, or even control that's limited and routine would be enough. So that would be codified into the language. Purple Communications is a case that essentially found that there is a statutory right for employees to use employer equipment, including emails and IT systems, to communicate about union matters. And for decades, the law of the land was Reserve Guard, which did not find that. Now, regardless of where the board lands, one thing I think is consistent, that even if you have a policy that says that you can't use a company email for personal reasons, it can't be enforced in some type of discriminatory way. So I think regardless of where the board lands, or if this is codified or not, that's the one thing that tends to stay the same about your policy about who can use email and for what purpose. Lastly is a case called Specialty Healthcare, and I'll quickly get into this. So this is a case that talks about oftentimes where a union may try to unionize a large facility, and maybe they don't have the full support of all the workers, and they'll try to cherry pick a sort of smaller unit. And so this case made it easier for a union to do that and put the burden on the employer to prove that they have to have a larger unit. We talk about what a community of interest is. You can't just organize a group of unrelated employees for various reasons. So that standard will make it easier essentially for unions to kind of target smaller, we call it micro units. And it's an administrative headache for employers to have to try to manage 20 different smaller units instead of one larger unit that probably should be together. Okay, and I'll just, for sake of time, I know we're over here, I'll try to just focus on a couple of other proposed changes. So outside of just actually codifying some decisions, there is an adoption of the California ABC test for determining independent contractor status. Mike got into that, but as the act reads right now, independent contractors are explicitly within the act excluded from the definition of an employee. This would obviously change that. You hear the term ambush or quickie elections, and that's just getting at the amount of time it takes from when a union files a petition to represent a group of employees to when that actual election occurs. Under the act, this would shorten it down to aim for an average of 21 days, which is not a lot of time for an employer who often will get caught off guard with a petition to exercise its legal right to inform its employees lawfully about what a union is and what they could expect, which I believe that's actually in itself within the act too, what you can actually say to employers. I didn't get into that, but that's also, there's some discussion on that in the bill as well. So if you're bargaining an initial contract, and you don't reach an agreement within 90 days, which is not uncommon and probably the norm, you would have to submit to binding interest arbitration, in which an arbitrator will come and essentially help the parties write the contract. Another thing important for those who may not even have a unionized workforce is reversal of the Supreme Court case that found that mandatory arbitration clauses are lawful. That was a big deal in 2018. I think the Epic Systems Supreme Court case, and so that would essentially overturn that Supreme Court precedent and require employers to defend sort of these costly class action litigations in court. Last thing I'll get to on this list, there's something in the bill for the NLRB having the authority to seek civil fines of $50,000 for failure to comply with an issued board order, which could be doubled in repeat violations. We see that in other acts, particularly in the Health and Safety Act for repeat player. There's a lot more just kind of punitive type fines to essentially punish bad behavior, but we don't really have that in the NLRA, and so the act seeks to include that type of work. And I lied, I want to just quickly hit one other point. The very last point, revised definition of 211 supervisory status. A lot of times employers rely on their sort of frontline supervisors, and they traditionally are not included in the bargaining unit, and they're important in an organizing campaign because they have a lot of the on the ground information, with them being so close to the work unit. So there's a revised definition that would essentially put those frontline supervisors in the bargaining unit, and from a strategic standpoint, that's a huge disadvantage to employers if that remains. So last thing, we've kind of already talked about some of these things, but we think that eventually some of these other decisions will be on the chopping block here, and I'll just single one out just for sake of time, and I'll focus on Johnson Controls, which recently made it a little easier if towards the end of a contract the employer receives evidence that the union no longer has majority support. What the law was for decades was that you could withdraw recognition from the union at your own risk. You can announce that you want to withdraw recognition, and you could do so, but at the time of the expiration of the contract, if the union is able to regarner support, it could defeat your claim, and you could also draw a ULP. So it was very risky for employers to try to withdraw recognition from a union on that basis. Johnson Controls, just without getting into the details, made that easier and required an election. And so the union, or an employer, if they had evidence that there is no longer majority support, they could withdraw that recognition, and there will be an actual election determine whether that's the case or not, instead of a ULP. So that's one of the decisions that we think may go back to the old way. So that just gives you kind of again, there's, like some of these other issues, we could spend an entire webinar on this topic, and maybe we will, but that kind of gives you an overview of what we think is on the horizon at the board.
Yeah, and to emphasize what Jason alluded to, for those of you who are still on the call that are not currently in the private sector and have a unionized workforce, if you take nothing else from this, you should be thankful you stayed on the line, because unlike under a Republican administration where you can say, oh, well, the NLRA, I don't have to worry about that, I'm not unionized. These issues can apply to all private sector employers because, what the push both at the board level and legislatively is going to be is to make it easier to organize employers, and also, give various means for non-union employees to assert rights, and the right to engage in protected concerted activity, the right to use employer email to do that, by going directly to the labor board, regardless of whether they're in a union or not, and regardless of whether the workplace is unionized. So we're over time, and we thank you for all your patience, and there are no questions. So obviously, if any of you do have questions that you didn't ask today, feel free to reach out to any one of us or one of your forensic attorneys, and we'd be happy to help you out. Thank you for joining us. We hope you found the program helpful. For those of you who do work for schools and are interested in education specific topics, please join us next week when we'll be providing a COVID update for our school clients. As a reminder, everyone logged in to today's program will receive an email that includes a link to the recording of today's webinar and a link to a feedback survey. For those of you who are lawyers and who are seeking CLE credit, you should complete and return the feedback survey so that you can receive the credit. Again, thank you for your patience and thank you for your attention today, and have a good afternoon. And for those of you in the snowy Midwest, be warm. Thank you.